Hello to all of you. Let me see if... okay. So I'll start my lecture at 2:30. Okay. Sorry for the delay. There's problem with Zoom integration, so I will just try to wait for others to join in, and then we can start with our afternoon session. But I would like to remind everyone to please have with you your the PowerPoint slides, because I won't be able to share them because of our problem with Zoom integration. So I have no choice but to do this manually, and I hope you will bear with me. I tried to prepare 74 slides for everyone so I can make this lecture understandable. But unfortunately, there's a problem with Zoom. We really tried our best to integrate our Zoom meeting, but I think there's a problem with the technology. So we have no choice. So I'll start my lecture exactly 2:30. So let's have kumustahan muna. By the way, I'd like to take this opportunity to thank the president of the Philippine Associations of Law Schools, our Dean Mari, for the opportunity, and of course Dean Alsuade of University of Cebu for the assistance. Is actually doing the technical work for the PALS Facebook Live. Okay, so I hope my audio is loud and clear. Yes, maayong hapon sa tanan. Good afternoon to all. Magandang hapon sa lahat. Assalamualaikum to everyone. Ramadan Mubarak to all those observing the holy month of Ramadan. So we have 547 audience at this moment. By the way, I'd like to congratulate also the graduating class of 2020, and of course our 2019 bar passers. You did a job well done, everyone. So can you please tell me if my audio is loud and clear? Okay, good. Alexander Tandok. Thank you very much. Mayong hapon din. Okay, so yeah, we can start at 2:30. So I hope you have your slides. Would be better, you know. I had my own printed copy, so I have to follow through these slides. Hello, Dean Torion. How are you? Hello, good afternoon, Dean Juan. This is my second time to do this. I tried this once on our Facebook page, and yeah, I don't know how should I describe my feeling talking to the phone. Okay, 3 minutes to go, then we can start a lecture. Again, I'd like to remind everyone to please have your slides, so we can would help, you know, if you have your slides with you. I really tried to have a haircut, but unfortunately, my quarantine pass wouldn't allow me to have a haircut. So please bear with me. Okay, so once again, good afternoon to all of you. Magandang hapon, maayong hapon sa tanan. And the topic that I will be discussing this afternoon is quite new to everyone, but not actually new in the Philippines. We'll try to know that why competition law is not actually new to the Philippine legal system. As you might have, I think, those who are following me on Twitter, that I've shared an entirely different point of view with respect to the closure, not actually closure, but the expiration of the franchise of ABS-CBN. Let me bring in this to our discussion because of the importance of competition law in the context of the ABS-CBN case. Those who might have read my short opinion about the controversy, that I try to look at the case in the context of competition policy and competition law. Yes, competition is important in the discussions of ABS-CBN because that would limit our options. That would also disincentivize other players in the market not to provide a better, probably better broadcasting services because there will be lesser competition in the market. While it's true to say that there is still competition in the market because you have EBS, you have Channel 7, you have Channel 5, you have PTB4. But that is not the point. The point is the competition, there is a listening of competition. And that's the concern of competition law. Why is that important? Why is it important that there is competition? May I call your attention to please prepare your slides so we can start. My presentation, the outline of my presentation we'll try to talk about the general principles of competition law. Then we will also try to look into a brief overview of the United States and European competition law system. This is important. This is not, I would like to inform everyone that this is not a strictly comparative discussion, but it's important that we talk about the European Union competition law system and that of the United States antitrust law because of the fact that the Philippine competition law or the Philippine Competition Act is modeled from these two systems. You will later on discover that our law is actually a fusion of United States antitrust law and that of the European Union competition. So that's the importance of why we need to talk about the US and EU competition law systems. We will also try to talk about the historical evolutions of Philippine competition law system. This is important so that you'll have a deeper understanding of the development of competition law in the Philippines, and that for you to understand that this law is not actually new in the Philippines. As a matter of fact, competition law Philippines is the first among the Asian countries to have competition law. So our competition law history is quite old. It has a colonial history. Then I'll jump into substantive liability provisions of the Philippine Competition Act. Given the time limit, I don't think I would be able to cover the entire provisions of the Philippine Competition Act, but this is just an introductory lecture, so we will cover those important provisions. The substantive liability provisions. What are those prohibited acts? Then I hope I will still have the time, and I'll talk about institutional enforcement framework of our Philippine competition. We'll talk about some of the procedural characteristics of Philippine competition law enforcement, the organizational makeup of the Philippine Competition Commission. Okay, so let's start with the general overview. Competition law and competition policy. Yes, they can be used interchangeably. If you're going to read literatures, at times they use competition policy or competition law. But we should know that while they are interchangeably, competition law and competition policy are not actually identical. When we talk about competition law, we talk about legal body of legal rules and standards, while competition policy is quite broader than competition law. You talk about formulations of competition policy in the first place. So we have that in our slide, the distinction of competition law and competition policy. It is also important that we also make a distinction between competition and regulation. Strictly speaking, there is a distinction between competition and regulation. That's why you also have your sector regulators. But under Philippine law, all competition issue is under the new law under the jurisdictions of the Philippine Competition Act. And you will also discover later on that while there is a distinction between competition and regulation, because in regulations there is more interventions on the part of sector regulators, competition has an aspect of regulations. So again, the two are not that far unrelated. Okay, so what is competition law? It's important that we define the term. What is competition law? By the way, our competition law in the Philippines is both a product of colonial transplant and congressional legal transplant, and we'll try to explain that. Competition law and antitrust law. You might be wondering, what's the difference between antitrust law and competition law? There's actually no distinction. It's just that in the United States they use the term antitrust law because of its historical significance to the trust at that time. So this is not, when you talk about antitrust law, this is not about trust as we understood it in civil law, okay? But the common term being used now is competition law. In other jurisdictions, they also use the term anti-monopoly, like, for example, in Japan. But again and again, if I will be using the term antitrust law or competition law, the two are the same, okay? I am just interchangeably using the term. If you're going to look into our Philippine jurisprudence, we use the term antitrust law. You can't find the term competition law. Okay, so I've also noticed that some are using the term anti-competition. That is not actually correct, no? It's an oxymoron, so it's not, you cannot use anti-competition. It should be competition law or antitrust law. Okay, so what do we mean by competition law or antitrust law? By the way, somebody reminded me JP Abilia. By the way, why do we have to talk about competition law? We need to talk about competition law because it's now part of, for the first time, there was an attempt last 2018 to include this in the bar examinations, but I think it was eventually dropped in the bar coverage. But now in 2019, starting these bar examinations, this coming 2019, 2020, I mean, which is now moved to 2021, competition is part of the mercantile law. So it's important that you'll have at least an overview of what is competition law. Okay, let's proceed to the definition because this is an introductory course, so it's important that we define the term. Okay, competition law consists of rules that are intended to protect the process of competition in order to maximize consumer welfare. So that's the definitions offered by Wish and Bailey. You will note that it gives emphasis on the protection to the process of competition. It's not the competition per se that is being protected by competition law, but it's actually the process, the dynamic process of competition. And these definitions of Wish and Bailey emphasizes the focus of competition law, that is to promote, to maximize consumer welfare. We'll try to define later on what do we mean by consumer welfare, because it's quite a problematic term in the context of competition law. Although consumer welfare is a well-defined term in economics, but not in the context of antitrust law or competition law. It is also concerned with ensuring the firms or undertakings, as it's used in the law, operating in free market economy do not restrict or distort competition. So you also talk about restriction or distortion of competition in a way that prevents the market from functioning optimally. Because if there is a market distortion, there is a market restriction again and again, the consumers, the public, will be affected if there is this distortion. It is also the study of competition. It is a body of law that seeks to ensure competitive markets through the interactions of sellers and buyers in the dynamic process of exchange. So, again, when we talk about competition law, again, we talk about ensuring competitive markets. Another definitions offered by Habenkamp is that it concerned with maintaining competition in the private market. So you will note that the definition seems simple. It talks about protecting the process of competition. It talks about ensuring that the market works, that there is no distortion in the market. It ensures that there is competitive markets. That's why cartel price fixing, for example, is illegal. So while the definition seems simple, competition is, without saying, very controversial. For example, it is hard to provide the definitions of competition. Everyone will agree, or to obtain a consensus about the reasons of having competition. So there is still debate among scholars. The debate is still vibrant as to whether, in the context of development, whether competition is really important in the context of development, in the context of developing countries. So that is quite a vibrant debate. There's also a controversy over the role of competition in regulating markets, and also debate surrounding the goal of competition law. And you will later on try to give an overview of what is the goal of competition law, or what are the goals of competition law. Because among the most widely debated aspect of competition law by scholars and even by the courts is the goal of competition law. What is really the goal of competition law? We will try to do that. as I've said again, competition law is not actually new in the Philippines. We do have a lot of jurisprudence dealing with issues on competition. So I'd like to quote one important provisions that has something to do with competition. And these decisions of the Supreme Court in the case of Gokongwei Jr. versus Securities and Exchange Commission, decided in 1979. This is in relation to the 1973, in relation to the Antitrust Constitutional Clause of the 1973 Constitution. Okay, so in this particular case, the Supreme Court described the nature of competition law. What did the court said? No, but what is this case all about? This Gokongwei case is a case where the Supreme Court used Section 2 of Article 14 of the 1973 Constitutions and Article 186 of the Revised Penal Code. In this particular case, the court took note that this antitrust law, referring to the Revised Penal Code, Article 186, we will later on discuss Article 186 as a penal competition regime. Okay, in this particular case, I would be better, but after this lecture, you try to read the full text of Gokongwei case versus Securities and Exchange Commission. I've cited it in our slide. What did the court note in so far as the nature of competition law? According to the Supreme Court, these antitrust law or laws referring to the constitutional clause on competition law and that of the Revised Penal Code against monopolies and combinations in restraint of trade are aimed at raising the levels of competition by improving the consumer's effectiveness as the final arbiter in the free markets. You see, under competition law, it's actually the consumers that are given that final arbiter in the market, whether to buy that product, whether to watch Channel 7 or to watch Channel 2. That's supposed to be left to the consumer to decide. These laws, according to the court, are designed to preserve free and unfettered competition as the rule of trade. And going back to the definitions that we have, this talks about unfettered competition. That is why you will note in the definition, competition law speaks about ensuring that the firms operating in the free market economy do not distort or restrict competition. So that is in relation to Gokongwei case. The court also further quoted U.S. landmark case of Standard Oil, where the United States Supreme Court said that, referring to competition antitrust law, it rests on the premise that unrestrained interactions of competitive forces will yield the best allocations of economic resources, the lowest prices, and the highest quality. If you have competition in the market, for example, if you have more competition, if you have more ABS-CBN, if you have Channel 7, if you have Channel 5, and you add more channels, that gives these competitors in the market the incentive to provide a better service, better product, because they know that if you're not going to produce a better product, you will move to the other product. There is substitutions. But if you only have one, for example, you only have Channel 7. Let's remove Channel 5, Channel 4. If you only have Channel 7, Channel 7 wouldn't mind of improving its own product, its own services, because you don't have a choice. That will not lead you to transfer to the other channel. So that's the importance of of having competition. It always leads down to the benefit of the consumer. Better services, better product, and lower prices. As a consumer, we are always concerned with lower prices. Kaya always tayo tawad ng tawad. Kahit mayroon pang price tag yung produkto, muhangyo gihapon, no, di ba? Would still ask for discount. Pag may sale, ang Pinoy, pag may sale, dadagsain ng mga malls. And that only speaks of the importance of competition law, because we always want lower prices. But of course, we don't just settle to lower prices, but poor products. Dapat balance. So that's what competition law is trying to address. You will have a better services, better products at a lower cost on the part of the producer, at a lower price on the part of the buyer. So I hope that makes it clear. Okay. So concept of competition law. What do we mean? What are the things that need to be underscored when we talk about competition law? Again, competition law is generally negative or prohibitory. In other words, competition law does not directly encourage competition or force firms to compete. No, competition law doesn't do that. I'll give you an example. When Grab and Uber, when Uber decided to leave the Asian market, and entered into an acquisition agreement, when Grab acquired Uber, because of the plan of Uber to leave the Asian market. We know that will lead to lessening competition in the market, because that leaves us to only one player, and that is Grab. And I think you know the impact of Grab, how as to pricing. But for example, can Philippine Competition Commission compel Uber to stay in the market, because leaving the market would lead to monopoly, of Grab to the market. No, it can. Pcc, the Philippine Competition cannot do that, because that is not the concern of competition. Competition law is not there to force you to go to the market, but rather the law provides certain provisions that would ensure certain limitations that would ensure that there is competition in the market. In other words, competition law does not directly encourage competition or force firms to compete, but rather seeks, through employment of specific rules, to prevent or eliminate any situation deemed harmful to competition, and in this way protect the process of competition. And this covers a variety of situations, ranging from those dealing with anti-competitive behavior or abusive conduct in the context of merger and in the context of monopolization. That's one concept that we need to highlight in the context of competition law. Another one, in a market economy, the consumer, not the state, dictates what goods and services are provided. Okay, that's, I think, self-explanatory. If there is a higher demand on for example, on face masks, then that leads to higher productions. Okay, that leads to higher production, because there is when we talk about competition law, again, it's also important that we put this in the context of supply and demand. Consumer demand drives production. So those are the basic concepts that are associated to the study of competition law. So let me proceed now to the goals of competition law. As I have said earlier, one of the most most debated aspect of competition law is what is the goal of competition law? What is the goal of competition law? I've listed three goals: economic, social, and political. Okay. Understanding competition law is not only, take note, is not only dissecting legislative text and judicial decisions according to settled canons of interpretations, but it's also about understanding the particular forces that have influenced the directions of competition policy at particular times. That's why it's important that we highlight the goal of competition. According to a very famous antitrust law scholars in the United States who wrote the influential book, The Antitrust Paradox. If you are a competition law scholars, it's always a must that we read the Antitrust Paradox because of its contribution to the development of competition law. Okay. Hello, Dean. Just while it's go promote consumer price regulations, we will try to. Okay, I will try to answer that as I'm going to go over the slide on the goals of competition law. Okay. According to Professor Bork, he opined that antitrust policy cannot made rational until we are able to give a firm answer to one fundamental question. That is, what is the point of the law? What are its goals? You will note that Professor Bork is the first who articulated the concept of consumer welfare as a goal of antitrust law, although not in the way that it's understood in the economic parlance. Okay, so goals of competition law. But it is now settled that the instrumental goal of competition law is consumer welfare, which is defined in economics, but nevertheless not well agreed, not well defined as an antitrust context or in antitrust law. According to another U.S. Antitrust law scholar, Professor Havenkamp, he said that after 30 years, the debate over antitrust ideology has quieted. Most now agree that the protection of consumer welfare should be the only goal of antitrust law. And that leads us to the economic goal of competition law. What is the economic goal of competition law? When we talk about economic goal, we talk about economic efficiency and the maximizations of consumer welfare. Okay, and this is considered, as I have mentioned a while ago, as the main goal of competition law. So what is consumer welfare? Consumer welfare. Unfortunately, it's embarrassing to note that there is an inability on the part of jurisprudence to converge into one meaning of the core of this core concept, the meaning of consumer welfare. But today there are two major groups of thought on the meaning of consumer welfare. One argues that the term should mean consumer surplus, and the other assert that the appropriate meaning is total surplus or aggregate welfare. In plain English, consumer surplus refers to the perceived welfare of buyers in a particular market, while total surplus refers to the perceived welfare of buyers and sellers in a particular market. Thus, the total surplus standard disregards wealth transfers between consumers and welfare and sellers. Okay, so that is the meaning of consumer welfare in the context of antitrust law. Competition law has also social goal. And you have it there on the slides, safeguarding the consumer from undue exercise of market power, dispersions of socioeconomic power of large firms, protection of democratic values and principles, ensuring market fairness and equity, mainly through wealth distribution in society. This is a very broad goal of competition law. But take note that an approach to competition law which embraces a social goal or objective, rests on antipathy towards the risk of private power and receives legitimacy from the principles of justice and economic equity in a market democracy. It has, as to quote former U.S. President Franklin Roosevelt, who once said that the liberty of democracy can be threatened if the people tolerate the growth of private power to a point where it becomes stronger than their democratic state itself. And so that's also one aspect of competition law when we talk about competition law in achieving a social goal. Competition law has also political goal. While this appeared to be questionable at first glance, several situations may arise in practice in which decisions of politicians prevail over decisions of competition authorities. As you will note that political institutions played a vital role in shaping competition law. Okay, so what about the Philippine Competition Law? What is the goal of the Philippine Competition Act? If you're going to examine the Declaration of Policy of Republic Act 10667, that is our Philippine Competition Act, you will note that our law manifests the three goals of competition law. There is that economic goal, there is that social goal, and also political goal. So our law has a broader goal, and this is one of the essential distinctions of competition law in developing world and in developed world. Because in developed world, in developed economies, it seems settled that the only goal of competition, or the goal of competition, is economic efficiency. It's consumer welfare. But in developing countries, they use, as is in the Philippines, use competition law not only to consumer welfare, but to other non-economic goals. So it has both economic and non-economic goals. So if you will read the Declaration of Policy under Section 2, you will find in the law such as talking about employment, talking about distribution, talking about trade. It talks about other non-economic concept. This has nothing to do with consumer welfare. So our law has a broader goal, as is usually typical in a developing country. Okay. Let's proceed to the characteristics of competition law. characteristics of competition law. Let's start. The first one is prohibition. What is this? Prohibition. The first characteristic of competition law that should be mentioned is prohibition. Prohibition. This brings us to the discussion of how competition law is prohibitory in nature and negative in its wording. Why it's negative in its wording? You have anti-competitive agreement. It's negative. Abuse of dominance. It's again in the negative term, in the negative wording. In fact, even antitrust law is also in a negative wording. You have your unlawful mergers or acquisitions, or prohibited mergers or acquisitions. So normally, the term used is in the negative. As that's why it's important that we deal about the first characteristic, which is prohibition. As a legal provision containing prohibition, we also have we applied this law to declare agreements illegal. Okay, so that's why it's prohibitory. So you have, in this context, you have your per se approach. Cartel, for example, the law prohibits fixing of prices. The mere agreement of two competitors to fix the price or to divide the market, o ikaw diyan ka lang magbibenta sa Quezon City, ako sa akin ang Pasay. That is market division. That is market distribution, which is prohibited by competition law. Okay, because that would have the effect of lessening the competition in the market. Why? Because it limits the choices of the consumer. Okay, another one, regulations. We talk about regulations. Competition law contains elements of regulations. A regulatory approach is adopted in relation to business phenomena where it would be necessary to conduct an analysis in order to determine the anti-harmful or the beneficial competitive effects or the pro-competitive effects. And you see this in the merger review. For example, in a merger review, the competition authority, the Philippine Competition Commission, in the case of the Philippines, will have to determine whether itong merger ba to, itong acquisition ba to, mayroon ba siyang anti-competitive effects? In other words, is it harmful to the competition? Is it harmful? Or mayroon ba siyang pro-competitive effects? Or is it beneficial to the competition? So the competition authority, through its merger office, use economic tools, conduct market analysis, and try to balance the anti-competitive or the pro-competitive effect. And that is where rule of reason comes into play. That is what rule of reason is. No? You balance you determine you balance the anti-competitive and the pro-competitive effects of a certain agreements. So that is regulations. Another important characteristics of competition law is exemption and exclusion. As you will note that even in our law, you have a provisions some dealing with exemption and exclusion. May I call your attention, for example, in the case of Section 21, talks about exemption from prohibited mergers and acquisitions. So a competition statute would always have this kind of exemption. Like, for example, in the European Union, they have this what you call black exemption, where certain agreements are excluded from competition law scrutiny. Okay, so that is also existing in the case of competition law. Exclusion in the context, for example, of a possible that prohibition on collusion may not apply to vertical agreements because a legislative decision was made to exclude this from the same prohibition. So it's again a choice on the part of the legislative body to exclude certain agreements, regardless of the fact that it has that element of collusion. I hope everyone is following through my discussions. Another important aspect of competition law is penalty, and this is very, very crucial. I tell you why is this crucial, because one of the reasons I articulated that one of the reasons why, despite that we have a long history of antitrust law in the Philippines, one of the primary reasons why there was a sort of under enforcement of our competition law as provided in the revised penal code, because of penalty. Take note that the penalty of Article 186 was never amended when this was, since in the 1930s, when the revised penal code took effect, until Article 186 was replaced by the provisions of the Philippine Competition Act. The penalty remains the same. Just imagine, 200 pesos. So there is no deterrence effect. That's why it's important that we talk about penalties. Now, modern competition law, you will see, as you will see, for example, in the Philippine Competition Act, that you talk about hundreds of millions as a penalty versus 200 pesos. One of the reasons why when the Sherman Act was transplanted in the Philippines, as it was later on converted into the provisions of Article 186, hindi siya naging importante, no? Naging parang police matter siya, because aside from the fact that it was included into the revised penal code, it would have been better if it remains a special law, special penal law. Dahil 200 pesos lang. But the source of that provisions, which is the Antitrust Act of the United States, grabe yung changes in the penalty to hundreds of millions of US dollars from that $6,000. No? So grabe yung change. So that's why penalty is very important. And you will note, for example, under the new law and the revised penal code, under the Philippine Competition Act, for example, first offense for administrative fines, you talk about 100 million first offense. Second offense, 100 millions, but not more than 250 millions. So that is why, so that's now the changes in the law. We now talk about hundreds of millions of penalty. But there are still some scholars arguing that the penalty provided in our law is still not enough to deter hardcore cartels. Okay? In terms of the market size of the Philippines. But at least to my mind, this is a huge improvement. That's why it is claimed that the Philippine Competition Act is hailed as a game changer insofar as competition enforcement is concerned in the Philippines. Another aspect of competition law, another characteristics is it's being interdisciplinary. Okay. Interdisciplinary. You will note that competition enforcement involves a lot of economic analysis. Hindi mo kayang ihiwalay ang economist in competition enforcement. It's always a dual system. You have a lawyer, you have an economist, because the economist is in charge in doing the market analysis. And that's very important. That's why when you study about competition law, I'm so sorry that earlier we talked about some economic principles In fact, it would have been more probably boring if, and you might be wondering whether am I really lecturing on subject matter in law or about economics, because competition law is very interdisciplinary. Okay, it involves some political ideologies and also economic thinkings. Okay. What are the factors that influence very quickly, that influence the shape of competition? This is very important in the context of the characteristic of competition law as being interdisciplinary. Okay, you have politics, economics, and institutions. Politics plays a vital role in competition law, in shaping competition law, because when we talk about consumer welfare, it's really an issue of a public policy issue. It's a public policy issue. So it plays a vital role in shaping competition law. Economics also plays a vital role in shaping competition law. And I'll give you, for example, in the United States, there is this debate between the structuralist and that the interventionist, the Chicago school and that of the Harvard school. So that's very important. In the European Union, for example, the ordoliberalism thinking also plays a vital role in the development of the European Union case law. Institutions also plays a vital role, because you'll note that there are different models or designs of institutions in the context of competition law. In the United States, for example, it's a tripartite system. You have the Antitrust Division, you have private enforcement, and you have the Federal Trade Commissions. And these three institutions, you can actually institute antitrust complaints simultaneously. So that's how it's being designed in the United States, tripartite. In European Union, you'll note that competition law is purely administrative. Walang criminal sanction ang European competition law. In United States, most of the antitrust cases are private enforcement. Private enforcement because of the triple damages, laking danyos, laking award sa private the firm that's being a victim of the anti-competitive or a victim of anti-competitive agreement or victim of abuse of dominance. So because of that, the choice is more on private enforcement. In the European Union, it's the more enforcement, more cases are premised on administrative enforcement. Now, in the Philippines, for example, it's also unique. It's an entirely different design, because while we seem to model our law to the United States and to the European Union, there's a distinctions. While we do have private actions, we also have criminal sanction. We have then administrative. We have the PCC. It's not actually tripartite, because private action, criminal action, is dependent on the actions of the Philippine Competition Commission. There must first be a prior inquiry. So, magkakaiba. So, these plays a very important role in shaping, addressing competition law. Okay, so let me proceed to what are the typical provisions that you see in competition law. So, yung magiging legal na tayo sa ating, what time is it now? Let me see. 3:17. I'll have to end my lecture. I hope I'll be able to finish it before finish the lecture at around 4:30. Okay, because I only have 2 hours. Okay, what are the common typical provisions that you see in any antitrust statute or any competition law statute? You have prohibition, number one. You have your prohibitions on collusion. horizontal and vertical situations. This is about, for example, cartel. To competitors fixing the price. For example, you have Toyota and Nissan fixing the price of the product. That they agreed that this is going to the price that we're going to the price for this product. So that is in the nature of collusions or horizontal agreement. Prohibition on abuse of dominance, that's also typical in a competition law. You have it in our law, the abuse of dominant positions. So let me go back again. Prohibitions on collusions in horizontal and vertical situations. If you have the Philippine Competition Act, that is in your section 14 of the Philippine Competition Act. So that is your prohibitions on collusions in horizontal and vertical situations. We'll try to explain later what's these horizontal and vertical situations. Then you have prohibitions on abuse of dominance. You have your section 15, your abuse of dominant position provisions. In the United States, they have the concept of monopolization or attempt to monopolize. That's the term. And then regulating mergers. We also have merger regulations under Chapter 4 of the Philippine Competition Act. You have from Section 16 up to Section 21. You have the provisions on merger regulation. So these are what I call the antitrust substantive liability provisions. Again, these are the substantive liability provisions. You have your anti-competitive agreements, your abuse of dominant position, and then your prohibited mergers or acquisitions. Okay, so what is the scope? What are agreements affecting competition? So we have horizontal agreements, vertical agreements, and then concentrations. And then unilateral conduct affecting competition. These are the scope of competition law. So let's have example. Hardcore agreements. Hardcore agreements, price fixing. We also have this. This is under the Purser rule. The moment that you agreed to fix the price, whether you have, take note, whether you have implemented the agreement, the agreed price, that is prohibited. That is it. Somebody asked me, I will not although delved on this, whether the IDP tariffs violates the provisions. Well, a straightforward answer, yes. No, it violates, it constitutes price fixing of services. And there are jurisprudence in the United States that declared it in violations of the antitrust law. So I leave it there, okay? Anti-competitive agreements, under Section 14, you have your price fixing, you have also your output restrictions. In most jurisdictions, like in the United States and European Union, output restrictions, territorial divisions falls under per se regulations, per se rule, per se approach, but not in the Philippine law. We will discuss this later on. Why territorial divisions is not falling under the per se violations. In other words, when we talk about price fixing as per se under the per se rule, you don't evaluate whether it has a pro-competitive effect or anti-competitive effect, because by its nature such agreement has a pernicious effect, and so it is deemed considered illegal. So as with output restrictions and territorial divisions under US and EU competition law system, but not in the context of Philippine Competition Act, because that is covered by your Section 14B. Cooperation agreements, we also have this, research and development, joint buying agreement, specialization agreement. These are also examples of horizontal agreements. but these are not under the per se rule, but they are being evaluated under the rule of reason analysis. Okay, example of vertical agreements. Vertical price fixing agreements. There are two vertical agreements. In other words, agreements involving, you have the manufacturer and the dealer. No, that's a vertical. No. But when you talk about horizontal, the parties involved are in the same chain. You have manufacturer. But in the vertical agreements, you have, for example, your downstream and your upstream agreement. So we can divide vertical agreements on our slide number 18 for one vertical price fixing agreements and vertical non-price fixing agreements. You have your minimum retail price, maximum retail price. You also have vertical non-price fixing agreements, which is exclusive distribution agreements, exclusive purchasing agreements, selective distribution agreements. Okay, let me check. Somebody's asking me, Dean, there's exceptions saying that an agreement that contribute improving. Okay, we will discuss that. No, that Vance, Earl, columnas, what you were asking is actually not under the per se rule, but that's in fact under the paragraph C of section 14 that involves your other, that's the catch-all provisions. That is a provision that involves that covers vertical agreements where you have to use the rule of reason analysis or the object or effect based analysis, plus that objective exceptions under the last paragraph, which we copied from Article 101, Paragraph 3 of the Treaty of Functioning of the European Union. We'll discuss that events Earl columnas. Okay, when we reach the provisions of the Philippine Competition Act. Okay, let me proceed. 3:25. Tinitingnan ko yung oras because ayaw kong sumobra. Okay, example of unilateral conduct. Unilateral conduct. These are unilateral because it's unilateral. Okay, gagaling, for example, to one entity or a group of entity. You have price discriminations. We have this in our law: tying, refusal to deal, predatory pricing. These are example of unilateral conduct. But take note that unilateral conduct is always associated with market power, because if you don't have market power, you don't have the dominance. Okay, it's unlikely that you'll be able to do this. Okay, because otherwise you will lose the market. No? But if you are a dominant position, you can always abuse the dominance and using this price discrimination, tying, refusal to deal, predatory pricing, and because of your market power, walang option yung ibang party, competitor, or the those other players in the market. Okay, so those are example of unilateral conduct. Okay, let me proceed now to an overview of the earlier competition regimes in the world. Okay, while it is the United States antitrust law that is considered the father of modern antitrust law. It is actually the U.S. antitrust law that shaped the world competition law. Kung mga, one scholar described the U.S. antitrust law as the most successful export product of the United States. And not only that, they have also used this during the colonial time. If we will, if we go back to for example, the case of Japan, where after the defeat of Japan to the Allied forces, one of the instruments they use so that Japan would not be able to rebuild its military might was actually the anti-monopoly law in order to disband the zaibatsu in Japan. So they use that. Not actually for, they say that it's for economic democratization, but the truth of the matter is that the transplantation of the antitrust law to Japan or the anti-monopoly law is more political. And that also happens in the Philippines. When the Sherman law was transplanted in the Philippines through let me go back. Where's my slide? Okay, when okay, where? Sorry. Okay, let me go back. Okay, so similar also the same in the Philippines, where it was during the colonial time, during the American occupations, that they transplanted, they imported the Sherman Law through Act 3247. And this 3247 is almost a copycat of the Sherman Act. Kaya ang tinatawag ko dyan is the Philippine Sherman Act or the Philippine Sherman Law. Pareho lang. But at that time, we don't need that law. But the only purpose why they transplanted that antitrust law in the Philippines was to build a European image. I mean, not European, Western image to our legal system. A United States image to our legal system. So it has a different goal at the time when it was transplanted in the Philippines. Okay. So as I've said again, it's not the United States that that became the first modern where is the slide? Again, earlier competition regimes. It is actually the Wallace Act of Canada that widely regarded by contemporaries as as the first modern competition law statute. But while it is the first statute, this law was not enforced. No, it was regarded as an empty political gesture by politicians who had pushed for it. No, in the context of social probably demand. No. The act prescribed behavior that unlawfully restricted competition in various ways. However, this amounted to deferring to common law restraint of trade, which allowed most competitions. So this Canadian Wallace Act was later on replaced by 3 subsequent competition law statutes. Then later on, they adopted the 1986 Modern Competition Act. Now, I also included here the Spanish Código Penal of 1870 because I discovered that we do have, there are actually 3 important provisions in the Spanish Código Penal that has a competition law aspect. And that's why I included here as among the earlier competition law regimes. Okay, but let's proceed to the U.S. antitrust law and the European Union antitrust law or competition law. And why is this important? Again, we need to look into this system, competition law system, because our Philippine Competition Act is modeled or borrowed from the EU and the US competition law. Okay, in the United States, the main these are the main antitrust law. They have the Sherman Act, okay, of 1890. You have Section 1 of the Sherman Act of 1890 that deals with cartels and market divisions, boycotts, vertical restrictions, typically imposed by an upstream firm on downstream firm. And then also historically, Section 1 of the Sherman Act also covers mergers. Section 2 of the Sherman Act covers monopolizations or exclusionary practices, which is the counterpart of the abuse of dominant provisions in the EU competition law. They also have the next statute is the Clayton Act of 1914. This Clayton Act involves something to do with the competitive harmful provisions that often operates to limit suppliers' use of wholesale pricing to make the distribution of its products more efficient under Section 2 of Clayton Act. And then you'll have Clayton Act Section 3 that covers tying and exclusive dealing. And all other practices prohibited by Clayton Act under Section 3, Section 1 of the Sherman Act, and Section 3 of Clayton Act are quite, quite similar. So that's why they are a bit superfluous. Okay, so you also have the Federal Trade Commission Act of 1914. Insofar as competition in European Union, we need to emphasize that it's two layers. You have the national competition law system because yung mga countries in Europe, in European Union, may mga kani-kanilang competition statute. But they have the European Union competition law, which is it's in the nature of a treaty. It's a treaty law, so it's under in the context of European Union, it is considered a constitutional law. So you have your provisions, the Article 101 of the FEU and Article 102 of the FE of the Treaty of Functioning of European Union. Okay. Another important distinction that we need to highlight, United States antitrust law is based on common law. That's why, according to the proponents of the Sherman Act, they are not actually, when they pass the Sherman Act, they're not actually passing a new law, but according to the framers of the Sherman law, they are merely federalizing the common law concept of restraint of trade. So it's based on common law. While the European Union competition law, it's based on the Constitution of European Union. You have the Treaty of TEC, Treaty of European Community, then it was later on amended by the Treaty of Functioning of European Union. So the competition law of European Union is based on the Treaty of Functioning of European Union. United States antitrust law based its standard on consumer welfare. That's why we discussed earlier that insofar as United States antitrust law, the goal is consumer welfare, and so they use consumer welfare standard in their analysis. While in the European Union, it's not just consumer welfare, but it's protecting the internal market. Protecting internal market. It's also important to, and you might be interested, you can do your research, two important school of thoughts or ideologies that had also shaped the antitrust law in the United States. You have the Harvard School of Harvard School, and you have your Chicago School. While in the case of European Union competition law, it's ordoliberalism. So what is this? Give you a very broad overview of what is the Chicago School. Well, the Chicago School of Antitrust law offered an elegant pro-market. So this is largely anti-interventionist. The consumer welfare model was first articulated by the Chicago School writings in 1950s to 1960s. But this was widely popularized by Robert Burke in his 1978 book Antitrust Paradox. So again, when we talk about Chicago School, It's pro-market and it's largely anti-interventionist. Building on neoclassical economics, Chicago school writers argued that in the long run, markets tend to protect their own imperfections, so lesser market intervention. On the other hand, when we speak of Harvard School, the Harvard School began in a much different place than the Chicago School, but has diverged much more from its historical roots. Traditionally, Harvard School was heavily structuralist. So Chicago School, anti-interventionist, pro-market, while you have the Harvard School, which is very structuralist, which means that it was apt to view markets as non-competitive whenever they deviated from what they were taught to be basic competitive conditions. So that's your Harvard School. So dumapo naman tayo sa European Union. So in European Union, we have this School of Economics, ordoliberalism. What is this ordoliberalism? This view, this ordoliberal economics, it takes the view that competition law should protect competition as a system, okay, and as a system. So that is the conception of the ordoliberalism. Okay, so again, you have here the EU versus US substantive antitrust provisions that I have discussed. So let me go over it again. You have the Sherman Act Section 1, Sherman Act Section 2, Clayton Act Section 2, Clayton Act Section 3, so on and so forth. And you also have your European Union competition law, your Article 101 TFEU on anti-competitive agreements. I would recommend that you download a copy of this Article 101 of the Treaty of Functioning of the European Union, which provides for the anti-competitive agreement, so you can make a comparison with our law, because it's important, because we borrowed some of the terms in this statute. The concept of by object or by effect was actually borrowed from the text of Article 101 of the Treaty of Functioning of the European Union. That question a while ago also about exception to per se rule is also borrowed from Article 101, that objective justifications involving the bifurcations of Article 101, Article 101, Paragraph 3 of the Treaty of Functioning of the European Union. You also have that Article 102 of the TFEU, which is the abuse of dominance, which is the counterpart of our abuse of dominant position under Section 14 of the Philippine Competition Act. So it's important that you read this, because it also provides the list of the conducts divided into two: your exploitative abuses and your exclusionary abuses. And of course, you have your EU merger regulations. The EU merger regulations is not the merger regulation in Europe is not based on the Treaty of Functioning of the European Union, but through a regulation, the EU merger regulation. Okay, so let me proceed to EU and US analytical framework. In the United States, they use the per se illegality rule and rule of reason. While in the European Union, they use the restriction by object. So there is that object box and there is that effect box. So yun ang pinagkakaiba. That's on our slide. Insofar as merger regulation is concerned, they are using substantially listening competition test in the United States, the SLC test, while in the European Union, they are using different merger tests. Now you have the substantive test. Some also use SLC, like in the UK. Some use dominant test, and now in the merger regulation reform, they have the the SIEC, significantly impede effective competition test. Okay. In Asia, let me skip that one. Now let me proceed to the evolutions of Philippine competition law system. I hope you are still with me, no? Okay ba? Kaway naman kayo dyan. Let me first read the comments. I hope you are still with me. Sorry if I'm boring. Because, yeah, my subject is very complicated. Okay. Oh, thank you, Commissioner T. Anong blockbuster? Okay, so let me continue. Medyo nag-relax lang tayo ng konti dahil alam nyo na, hindi pa tayo kumakain dahil sa fasting. Okay, so the next slide that we will talk is evolutions of Philippine competition law. I hope medyo nabigyan ko kayo ng konting background on competition law. I know that medyo mabilis ako because of the time I need to cover everything, and also the law is complicated. It's a very complex law. So I hope naintindihan nyo. So let me proceed to the evolutions of Philippine competition law system. Okay, I hope you're there. Okay, let's proceed to the slide on slide number 26 on the evolutions of Philippine competition law system. Okay, I will discuss 3 stages of transformation. These are the Philippine Competition Act regime. No? These are the transformations of our Philippine competition law system before Congress enacted the Philippine Competition Act. Okay. Again, I would like to emphasize that Philippines is the first in Asia to have a competition law. Okay, that's something that you should remember. So this law is not new. Competition law or antitrust law, depends on the term, plays also a vital role in the hybridization of our legal system or the union of civil law and common law. So naging parte yung ating antitrust law. No, in fact it's among the drivers of the merger or the union of competition, the union of the civil law tradition and the common law tradition, the Anglo-American common law system. Okay, that's the first stage. The second stage that we're going to discuss is the transplantations of the American laws. No? When the Sherman Law was transplanted, when the Clayton Act was transplanted. This is not known to many, but the provisions of the Clayton on merger regulations was earlier transplanted in the Philippines. That is why the concept substantially listening competition is not new in the Philippines. It's been there. It has been there in the old Corporation Act, but the revisions tinanggal. So it's not new. We have that. So nothing is new actually to the Philippines. Then the next aspect is the modernizations of the penal code. The modernization of the penal code plays a vital role here for the development of competition law because they transformed this very special, unique law to our penal system that becomes a felony. And then the next stage is the constitutionalization process, which is also very unique in the Philippines because we are the only country in Asia also that placed competition law to a higher standard. It is a constitutional norm, which is quite similar to the European treatment of competition law because it's based on the Constitution of the European Union, which is the Treaty of Functioning of European Union. Okay, so let's start with very quickly 1565 to 1898. That's the Spanish period occupations. We have the penal code based on the Spanish Código Penal of 1887. up to 1880s, and then we have the Penal Code of 1887, which was adopted, implemented in the Philippines on July 14, 1887. Okay, so under this penal code, you have there the penal code relevant provisions. You can just read this article. You have Article 542, Article 543, and Article 544. These are based on taken from the old penal code, not in the revised penal code. What are these relevant provisions? I hope you please read the it's on the slide. Article 542 makes it a crime for a person to solicit any gift or promises as a consideration for agreeing to refrain from taking part in auction, public auction. So this is a sort of a different concept of public auction or bidding, a special form of bidding regulated under Article 542, which is it has a competition law element. Article 543 talks about combinations for the purpose of lowering the conditions of labor. And then you have Article 544, which involves spreading false rumors, etc., etc. So take note that the act falling under Article 542 to 544 would clearly be an agreement in restraint of trade, and therefore they are competition law statutes. Why are we discussing this? Because you will note later on that these are connected together. The penal code, the revised penal code, and then the Philippine constitutions in building our competition law system. Okay, so let me proceed to the marriage of civil law and common law traditions very quickly. It is, if you look into, I call your attention to the case of Alzua versus Johnson's, Henry Shoup and United States versus Abiog. These are important decisions of the court that recognizes the existence of Philippine common law. Okay. I don't have to read the highlights of these cases because we are running out of time, but it might be interesting for you to read the text of Alzoa, Henry Shoup, and United States versus Abiog. It's very, very interesting cases. Okay, but take note, class, that in the entry of American laws and common law principles in the Philippines after the transfer of sovereignty from the Spanish occupation to the American occupations, you would normally expect that during the Spanish occupations, mainly we are using civil law traditions. You might expect that the coming of the Americans, they might abrogate everything and replace it with a common law tradition. That's not the case. What had happened was that the entry of American laws and common law principles did not supplant, but it rather supplement the major laws left by the Spaniards. So kaya nagkaroon ng union of the common law and civil laws, we will discover. Okay, a very important part of this union is the common law contract in restraint of trade, because this term is still existing and the fundamental basis of our antitrust law now, as it is being articulated in our constitutions and in several jurisprudence. So what is this common law contract in restraint of trade? We don't have this. We don't have this in our civil code. Normally, if a contract during that when we the dominant view was when we don't still have this concept of restraint of trade, when a contract is entered into and it is deemed in violations with the law, the provision that's going to be used is the civil code. But what happened is when the Americans started to shape our jurisprudence, they started using this concept. Instead of using civil code provisions, they used this concept of restraint of trade, and that's the beginning of the common law principles shaping the Philippine jurisprudence during the time of the American occupations. So what is this common law contract in restraint of trade? Under common law, a contract in restraint of trade embraced agreements restricting a party from engaging in a particular trade or occupation, or restricting the time, place, or manner in which the trade could or occupation could be engaged. So that is the definitions of contract in restraint of trade. The earliest reported case of this common law contract of restraint of trade was in 1414, which involved a case where the defendant was restricted from engaging in trade of dyeing in particular location for a prescribed period of time. The Court of England, the Court of English, the English court, because this was in a common law jurisprudence, condemned the restrictions as contract in restraint of trade. So that was the first reported case, the John Dyer case of contract in restraint of trade. And this was followed by the more popular Michel versus Reynolds in 1711. This is the most famous common law restraint of trade case. This case was an action of debt upon a bond enforcing a baker's covenant incident to sale of his bakery. The plaintiff in this case had entered a contract to lease a bakehouse for a period of years on the condition that the lessor, also a baker himself, would refrain from engaging in the bakery business for the term of lease, which is 5 years. In short, the defendant had promised not to compete for that period, and as also held in the Dyer case, the court held that such stipulation, which is ancillary to a valid transaction, was unenforceable because it is a contract in restraint of trade. Now, what is the relevance of these concepts? Now, if you will look into the case that I have cited in the slide, the case of Alizedney versus Giselle in 1916 and that of Ollendorff in 1918, please read the two cases because they are very important. The two cases are quite similar to the discussions in the Dyer and in the Michel case, where in this particular case you will see how the court used common law principles of restraint of trade and make that comparison of the ordine publico and the public policy concept, and saying that there is no distinction between common law and civil law. So please look into the case of Alizedney and Ollendorff. But very briefly, in sum, Alizedney and Ollendorff illustrated the Philippine common law contract in restraint of trade as though developed in the context of the marriage of civil law and common law. Okay, let me move faster. Transplanting the Sherman Act. This is very important. Again and again, as I've said earlier, the Sherman Act of the United States was transplanted in the Philippines in December 1, 1925. Under your Act number 3247, otherwise known as an act to prohibit monopolies and combination in restraint of trade. Now, if you're going to make a comparison of these provision and that of the Sherman Act, almost similar, napaka-identical. Even the provisions in both laws, the Sherman Act of the United States and this Act number 3247, talks about contract, combination, or conspiracy, and they are all in broad, vague language. But this law was later on replaced by the revised penal code. No, when the penal code was revised, was modernized, that lead to the revised penal code. One of the amendment, one of the revision that the penal code did was to incorporate Act 3247 in the revised penal code. So what they did is that they tried to merge. It's on the slide. No, I will not discuss about the feature of the revised penal code. If you immediately proceed to Article 186 of the revised penal, you will note in the slide the development, that the evolutions of Act 3247 to Act 186. Okay, so obviously most of the elements in Act 3247 was incorporated in Article 186 of the revised penal code. Article 186 of the revised penal code was our oldest competition laws that became also the basis of the provisions of the 1973 Constitution and the 1987 Constitutions. Okay. Let me proceed to the constitutionalization process. As I have mentioned earlier, one of the important aspects of competition, the history of the Philippine competition law, is its evolution into a constitutional norm. That is why I did argue that the cease and desist order may be considered a violations of competition policy, because the concept of competition law in the Philippines is now considered a constitutional norm. It is not just merely statutory, if you're going to read it in the context of the of the 1987 constitutions. So constitutionalization process. Again, I'd like to emphasize we are unique in Asia because we do have a constitutional provisions on competition law. So where did we get these provisions? The provisions of the first provisions was Section 2 of Article 14 of the 1973 Constitutions that was cited in the Gokongwei case. Then later on, this was carried to the 1987 Constitution under Section that's not Section 10. I'm sorry. No, that's Section 19. No, I'd like to correct that one. That's again a typo even on my tweet. That's Section 19 of Article 12 of the 1987 Constitution. Okay. So please correct that slide. No, on slide 38. That was similar to the 1973 Constitution, only that in the 1973 Constitution, it only talks about private monopoly. But in the 1987 Constitution, it included public monopolies. And you will note that the 1987 Constitution used the standard of public interest. Now, let me read the provisions because it's very important of the 1987 Constitutions. Section 10 of Article 12 of the 1987 Constitution provides, the state shall regulate or prohibit monopolies when public interest so requires. Now, let's proceed to the second sentence because it's very important. No combinations in restraint of trade or unfair competition shall be allowed. So it's if you're going to read the text, it's almost absolute. In fact, the earlier interpretations of the U.S. Court of the Sherman Law, which this provision was derived, was also quite a literal interpretations. That it would appear that almost all combinations in restraint of trade, all form of agreements would be illegal if it would constitute restraint of trade. Okay. So why is this important? Why do we talk about the revised penal code? Why do we talk about Act 3247? Why do we talk about combination restraint of trade when we have a new law? You might be asking me that you might be wondering that sinayang ni Dean Ditucalan yung oras natin nakinig sa mga repealed na batas. No, it's not. It is because this is what's unique. The provisions of the constitutions are derived from Article 186. So notwithstanding the fact that the revised penal code, Article 186, was repealed by the provisions of Philippine Competition Act or Republic Act 10667, they remains relevant because they are transformed into this concept where translated into a constitutional norm. And so, according to, if you will look into the deliberations of the members of the commission, Constitutional Commission, Section 19 of Article 12 of the 1987 Constitution, similar also with that separate provision on commercial mass media, is to be interpreted, this is the language, is to be interpreted in the context of antitrust legislations or jurisprudence on antitrust legislations. And it has to be read in the context of the revised penal code. In fact, it was asked during the deliberations whether the commission, the Constitutional Commission, was actually building a different meaning, different interpretations of the phrase like monopolies, combinations of trade, restraint of trade, and unfair competition. The answer of the proponent was that no, these terms are to be read as used in the revised penal code. So that is why, notwithstanding the repeal of the revised penal code of Article 186 and also the historical development of restraint of trade, it's still important because of these constitutional provisions. Okay. And so, Tatad versus Secretary of Department of Energy said it beautifully. Section 19 of Article 12 of our Constitution is antitrust in history and in spirit. So, I think that sums it all. You can read that case. Now, I have, for the 30 minutes, I will try to discuss the Philippine Competition Act. Okay. Kaya pa. Pahinga muna ako. Okay. Whew. Fighting. Okay na? Okay kayo dyan? So, pahinga muna ako ng 1 minute. And then, we will talk about the Philippine Competition Act. So, we're done with the general principles. We're done with a brief overview of the EU and the US competition law system, which is very important, as I've said, because you will later on discover doon natin kinopya yung ating batas. Then we also talk about a very brief historical development of competition law system from begin with its colonial importance as a colonial implant, then how it played its role in the hybridization of our legal system, the marriage of civil and common law, and how also common law was transplanted in the Philippines, and then the process of the modernizations of our penal code, and then finally to the constitutionalization process of our competition law or our antitrust law. So let me begin with the Philippine Competition Act. I hope you are still with me. Okay, so please bear with me. Okay, Philippine Competition Act. The Philippine Competition Act, or Republic Act 10667, is the oldest pending bill in Congress. The oldest pending bill. It took Congress to pass this law for about 25 years. It's 25 years in the making. It is viewed by the government, by the Philippine Competition, as a game changer. But again, it's a game changer, but it's not new. According to the chairman of the Philippine Competition Commission, it's a step in the right direction. I certainly do agree with the observations of the chairman of the Philippine Competition Commission. But if you're going to read what motivated Congress to pass this law was its commitment to the ASEAN economic integration. Okay, this law was signed into law on July 21, 2015, and it took effect on August 8, 2015. In a nutshell, the Philippine Competition Act mandates the creation of a national competition authority, which was actually lacking. My thesis argues that one of the factors that really contributed to the unenforcement of the Philippine competition of the antitrust law then under the revised penal code was the lack of a counterpart of the antitrust divisions of the United States. In fact, only in 2011, when the government realized that we need to come up with a special division of the Department of Justice, the Office for Competition, but it was too late. But anyway, we have now this modern law. Okay, so what are the motivations for its enactment? According to the records of this law, the congressional records, there's a need to consolidate the numerous fragmented and scattered competition law statutes. That was one of the motivations of our Congress. There's need to have a specific central body, and that is the Philippine Competition. It's a commitment to ASEAN economic integrations, and also provides for. They also argued on so many on other aspect of what is it? Sorry, the non-economic aspect of non-economic goal of our Philippine competition. And if I may articulate in the records, the bills passed in Congress, among the motivations was talks about the broader economic and non-economic goals, such as to level the playing field for business, to allow more Filipinos to exercise entrepreneurial spirit, to encourage competition, innovation, to usher investment, economic development, and to help eradicate poverty. It's very unique, no? Because we do have this even social goal in our competition law. Okay, so we have the important substantive liability provisions. You have Section 14, we've been mentioning that one, your anti-competitive agreements, then Section 15, the abuse of dominant position, and then your Section 20, your prohibited mergers or acquisitions. Okay, so what do we have? What on Section 14, the anti-competitive agreements? Importante ito because it's going to be part of itong aspect na to, yung sinama sa syllabus. So let me please get your slide on anti-competitive agreements. Slide number 45. Horizontal, our Section 14 is divided into three parts. Your paragraph 1, paragraph A of Section 14 speaks of horizontal per se agreements. Now, your price fixing and your bid rigging. Price fixing, this is your restricting competition as to price or components thereof or other terms of trade. So this is under the per se violations. In other words, it's illegal per se. The mere existence of the agreement will render those competitors involved liable criminally, administratively, and civilly. No? So that is your horizontal per se agreement. Take note that Section 14 applies only to competitors. That's why it speaks of horizontal per se agreements. Second paragraph, paragraph B. And so what's the element of this one? The element of Section 14, There is a horizontal agreement. The parties are competitors. The purpose or object of the agreement is to fix or rig a competitive bidding. Okay, next paragraph, your section 14, paragraph B, is your product limitations and your market divisions. But what's interesting in this provision is that there is a combination of the U.S. and European Union competition law on object or effect. It speaks of, if I may read, the following agreements between or among competitors which have the object or effect of substantially preventing, restricting, or lessening competition shall be prohibited. But according to the deliberations of Congress, this section is going to be the counterpart of the rule of reason. So in other words, section 14 will be evaluated under the rule of reason analysis. The court will have to look into the pro-competitive or anti-competitive effect of this agreement. But this is interesting because under EU law and under the US antitrust law, this paragraph B is considered under the object box, which is the counterpart of the per se rule in the United States. Okay. What is an agreement? It's important also. So let's proceed to section paragraph other agreements. Again, please correct the slide. That's supposed to be other agreements, section 14, paragraph C. No, that is your rule of reason with objective justifications that provides this. So other agreements other than those specified in paragraph A and B of this section, which have the object or effect of substantially preventing, restricting, or lessening competition shall be prohibited. So this speaks of those not included under restricting, under price fixing, bid rigging, market allocation, market divisions, or and also vertical agreements are covered by paragraph C. But this section is subject to objective justification, which is also the which was borrowed from Article 101, paragraph 3 of Treaty of Functioning of European Union. Okay, so again, you have paragraph A, B, and C. So please correct the slides on slide 47. Okay, let me proceed to, so what is an agreement? So it's important that you also look into the agreement definitions. Take note that the agreement definitions under the Philippine Competition is very, very broad. The definition speaks of any type or form of contract, arrangement, understanding, collective recommendation, or concerted action, whether formal or informal, explicit or tacit, written or oral. So that definitions under section section 4B should be read in conjunction with the meaning of agreements under section 14. So kaya importante yon. Okay, so let's see how this hybridization. I have here the figure that illustrate the fusion of the European and US law. You have this per se rule, and in Article 101, the object or effect, and then you have, you know, how this law was transformed into a tripartite form, no? Because in the Philippines, you have per se, you also have the per se plus object plus effect plus the SLC, no? And then so on and so forth. And then the next slide also, that also illustrate the reasons why nagkaroon ng ganitong model, which is very complicated. Well, because of the versions, magkaiba yung version ng Senado at saka House, and so that resulted to these hybridizations. So what happened? Based on the bicameral committee conference, they tried to reconcile the versions of House Bill 5286 and Senate Bill 2282, and then they come out with this distribution. So you have the per se, section 14A, object effect plus SLC, section 14B, which is rule of reason, or the understanding of rule of reason, which is quite the opposite, because object is never the counterpart of rule of reasons in the context of European law. And then you have the object plus effect SLC and any objective justification. But anyway, just leave it that way. That is your provision. So it was asked in the syllabus, saan ba yung rule of reason? Rule of reason analysis placed in your section 14B and section 14C plus the objective justifications, while section 14A speaks of per se rule. Okay, what is the effect of entering into anti-competitive agreement? Well, the contract is deemed void. Parties involved are to be subjected to administrative sanction, criminal prosecution, and private actions. And take note that it is enough that they agreed to fix the price. They agreed to divide the market. The law does not require that they have really executed the agreement. Okay, because what is prohibited here is the entering of this form of agreements. Because you don't evaluate in the context of per se rule, you don't evaluate the effect of this agreement because they are considered on its form illegal, under section paragraph 14, paragraph 8. Now that with respect to price fixing. But in the context of market divisions, under Philippine law, not in the United States or in the EU law, but under Philippine law, the existence of a contract is not enough because the law requires that the law requires that it must substantially prevent or lessen competition in the market. So it involves rule of reason. There's a need to balance, to evaluate whether it has anti-competitive or pro-competitive effect. So I hope that's clear. Now, the first, we have a first insurance section 14 case, the insurance pool case. This I will not discuss the merit of this case because this is now pending in the Philippine Competition Commission, the insurance pool case. The charge was on section 14, paragraph C. Let me proceed to abuse of dominant positions. Oh, I have only 10 minutes. Abuse of dominant position, we need take note, class, that take note, ladies and gentlemen, that what is illegal is not that dominant position. Having that market power is not illegal. What is being prohibited by law is that abuse of dominance for the firm to exercise that conduct that constitute exclusionary or exploitative. Yun ang pinagbabawal ng section 15, no? So in other words, bigness per se is not illegal. What is illegal is for that entity or undertaking that has a market power, at least 50%, that's the rebuttable presumption that one is a dominant player in the market. So what's being prohibited by law is the conduct. Okay, so there are 4 ways to think about market power: as an ability to increase price, as commercial power, the ability to exclude rivals, and then as a formal jurisdictional test. So those are the way how you think of market power, because the conceptualizations of market power is essential in competition law. Okay, so I listed here the abuse box under section 15, no? Yan yung mga nakalagay dyan. Under the law, this list is exclusive. This list is exclusive. But under the implementing rules and regulations, according to the implementing rules, it's non-exclusive. But my view is that no, this is exclusive. The original draft was that these lists are not exclusive, but later on, during the bicameral committee conference, they removed because they want that the listing should be exclusive. So I don't agree with the implementing rules. My view is that these are the only list. These are the only abusive conducts under section 15. Okay, so Just take note, predatory pricing, imposing barriers to entry, bundling or tying, price discriminations, restrictive vertical agreements, resale price maintenance, refusal to deal, exclusive arrangement, imposing unfair price, limiting production. But take note, only a player, only an entity that has a market power can be subjected to this provision, because it speaks of abuse of dominant position. Even if you don't have that dominance, that market power, and you are doing predatory pricing, then you will not be liable, because normally you will not have the capacity to sustain such exclusionary or exploitative conduct. Okay, so that is insofar as this abuse or abusive conduct box. It's there. Now, role of intent. Intent under our law is, my view, is important in the determinations of whether one is liable for abusive conduct. Why? Although this is debatable under European law, which we borrowed this section 14, but there is a distinction under the EU law. It's it's under objective test. But if you note, if you will look into the provisions of section 15, it added an SLC test, and therefore that would require, therefore, for an effect-based analysis. And so intent is going to be essential. That is my view in determining whether a dominant player is liable for abuse of dominant position. Okay, so under what are the standard of analysis? It's important. The standard of analysis, anti-competitive agreements. You have the per se rule, object plus SLC. That's the rule of reason. Then your object effect plus SLC, object justification or rule of reason. Abuse of dominant position, you have your conduct plus SLC or rule of reason. Take note that rule of reason was never mentioned in the law, although it's being discussed during the deliberation of the House. They've been referring to the rule of reason, although not correctly, but we have to leave it to the statute. I mean, that's how they formulated the law. Rule of reason is equivalent to conduct plus SLC. What is also unique in our abusive conduct provision, our abuse of dominant position, was the fact that we included an objective justifications, which is also present in anti-competitive agreement, which are not present in the European law. So in Article 102 of TFEU. So what happened in the abuse of dominant position? This is the process. Well, of course, after doing the market definitions, because that's in part relevant market, then you have to determine whether the conduct of the dominant player falls under the object box. Kasama ba doon sa listing natin? And after that, you may also ask whether the objective justifications will apply. Whether it has a which is provided under section 15. Okay, but there is somehow but take note of section 26. Section 26, which is, to me, that blurred the characterizations that we discussed under Article 14 and 15, because Section 26 provides that it did not make any distinctions under Section 26, which is your rule on the determinations of anti-competitive agreement or conduct. To me, this was not totally correct. But there was a mistake in the final drafting of these provisions, because to me, what the problem is that it created that it created a situation where there is a conflict between the characterization under Section 14 and this Section 26. Because under Section 26, it would appear that all anti-competitive agreements, all abusive dominant positions are subject to an elaborate rule of reason analysis. That's the problem. So we have to wait for how the Philippine Competition Commission, eventually the court, and how the court and the PCC will reconcile this paradox, no, of Section 14 and that of Section 26. Okay, so relevant market definition is important. When we talk about market definition, we talk about market substitutability. So just to read Section 24 on market definition, because it's important that before you can even apply, determine whether an entity is liable for an abusive conduct or exclusionary conduct, you must first evaluate whether he has a market power. And doing that, you need first to define the market. The relevant product market, the relevant geographical market. And so among practitioners, if you are for the complainant, then you will try to define the market in a broader way. But if you are on the defendant, you will try to narrow down your definition so that it will appear that the conduct does not fall within the relevant market. Okay, so what is substantially preventing, restricting, or lessening competition? It's very important because this phrase was mentioned in all the antitrust liability provisions. It is listed in your Section 14B and C. It is part of your abuse of dominance, and it is part of your prohibited mergers. And this, made even more complicated our standard of analysis because SLC is used in merger regulations and not in abuse of dominance provisions and not on anti-competitive agreements, because iba ang standard of analysis. But unfortunately, it's in the law, no? Kaya nga sabi ko, dahil part of the fusion. Okay, so the first abuse of dominant case, and I think you might have heard this, was the Urban Dica Home Manila Condominium Corporations, wherein this case, the PCC filed a case of exclusive dealing, but this was not. But this case was not decided on the merit because eventually the Urban Dica Homes did not challenge the statement of objections, but rather it entered into a settlement, and it paid a fine of 27.11 million. Okay, Section 14 and 26 paradox, as I've said again, there is a distinction, but the the IRR tried to correct the seemingly contradiction of Section 26 and Section 14, and in the IRR it speaks of for appropriate cases, which I think right and logical that the Philippine Competition Commission has added the phrase for appropriate cases. But if you're going to read the statute, it would appear that it did not make any distinction. But we have here the IRR that tried to correct that paradox of Section 14 and Section 26. Okay, let me proceed to the merger and acquisitions. Okay, merger and acquisition. Anyway, our live is only up to 4:30, but if I can, hingin ko lang, we'll try to finish this until 5 p.m. No, if those who can still stay with me, kahit wala, but anyway, this is going to be recorded, and then you can just play it later on. So I'll just finish everything. No, I have few remaining slides so I can cover mergers and institutional makeup of the Philippine Competition Act. Okay, let me proceed to merger and acquisition. Of course, you know what is a merger and what acquisition is. When we talk here of horizontal merger, is a merger of entities whose product or services directly compete in the same market. Yun ang pinaka-tinitingnan, no? That the merger that is covered by the merger regulation are those horizontal merger of entity whose products or services directly compete in the same market. We also have a non-horizontal merger, which can either be vertical merger or a conglomerate merger. Okay, a vertical merger involves entities operating in different levels of production chain, production supply chain. That is, suppliers or customers of one another. So, for example, here you have the downstream and your upstream firm merging, you know? And also a case of conglomerate. Okay, so what is important in the merger regulations for the purpose of the bar examinations, I think, is your compulsory regime. Your compulsory notification requirement under Section 17. Okay, tingnan nyo Section 17. What is in these provisions? Under Section 17, it requires a parties to a merger or acquisition to notify the Philippine competition before they can consummate the merger or acquisition. Now, I pointed out that this was overlooked by the revisions of the Corporation Code, the latest revisions. It failed to consider these existing provisions because the final approval of a merger acquisitions, when it falls under the compulsory, it's going to be the PCC, because a merger or acquisition, when it falls in the threshold requirement, will be considered void ab initio, even if it's approved by the Security and Exchange Commission. It is going to be void, and the parties will be subject to a huge administrative fine. Okay, so what is this Section 17? Compulsory notification requirement. If it reached the threshold requirement, in the law, by the way, baka you might be confused. Under Section 17, it speaks of the threshold, speaks of 1 billion. Okay, the value of transaction exceeds 1 billion. In other words, if the value exceeds that, it's going to be subject to mandatory compulsory notification. But that was revised twice already by the Philippine Competition Commission, because the law allows the PCC to adjust the threshold. Pwede nilang babaan, pwede nilang taasan. It depends on the market conditions of the Philippines. And because to their mind that there's a need to adjust the threshold kasi dumadaming pumapasok sa kanila na merger review. No, di na nila makaya, and I think our also market is big, and that the threshold 1 million is too small. So they've increased the threshold, and now very recently they have again increased the threshold. So this is the threshold. The threshold is 5.6 billion for size of person, 2.2 billion for size of transaction. Okay, if the merger or acquisition met that threshold requirement, they cannot enter into they cannot consummate the merger. Upon reaching a definitive agreement, they have to notify the Philippine Competition Commission, and they cannot consummate that within a period of 30 days. That's the 30-day waiting period of notifications. If the merger or acquisition, the parties has consummated the merger or acquisitions, and the transaction falls within the threshold, that will be considered void ab initio, and the merging parties will be subjected to a fine of 1% to 10 to 5% of the value of transaction. It's a very huge. Okay, it's very huge. It's very huge. Even if such merger or acquisition does not lessen competition in the market, what is being punished here by the law is the failure to notify the Philippine Competition Commission, because we've adopted a pre-merger notification regime. Okay. The first important case that was decided by the Philippine Competition Commission, and you might be interested to read, the decision is available in the internet, is the Odina Corporation. In this particular case, then take note that the only involved in this case is Odina failed to notify the Philippine Competition Commission. And so, upon evaluations, the transaction satisfies the size of transaction test, and therefore they should have notified the PCC before consummating the before consummating the merger. And so a complaint was lodged to the PCC. The PCC conducted and motu proprio investigations, and it found out that yes, there was really no notifications, and so the PCC voided the merger, and then subjected the respondent Odinia Corporation and KGL to an amount of 19,667,175.9, which is 1% of the value of transactions. There was this is not a unanimous decision, because one of the commissioners dissented, argued that the commission should have used his forbearance power, and took into account this is a first case, but the majority of the commission agreed that no, the law does not allow any exception, and therefore, and it does not also empower the Philippine Competition Commission to exempt or forbear a violator. But given that this is the first time the court the PCC did mitigate the penalty into just 1% of the value of transaction, but it's still huge. No, imagine it's 19 million. Oh my God. Okay. The next case is the grab over case, which I think you all familiar. In this particular case, there was no notification in the case of grab over case. Why? Because after evaluations, the transaction cost did not breach the threshold. And so, what happened in this case? The Philippine Competition filed a motu proprio, conducted a motu proprio investigations, and then the Merger and Acquisition Office found that there is indeed an SLC, effect of the acquisition of grab over. But eventually, the investigations was terminated because Grab filed the request for voluntary commitments, and then a decision was issued by the PCC allowing the voluntary commitment of Grab, and so it listed several conditions, and you will note that there have been instances there recently wherein Grab was fined by the Philippine Competition Commission for violating the conditions of the conditions of the voluntary commitment. Okay, for merger review, there are two phases of merger review. You have your first phase, which is review takes for a maximum period of 30 days from complete notification and payment. This involves assessment to determine if the notified merger raises competition concerns that would warrant comprehensive review. If it does warrant, then the merger and acquisition office proceed to the phase 2, which is a more detailed and in-depth assessment within a period of 60 days. What is the effect? If no SLC, the merger and acquisition is cleared. If with SLC, either the PCC will prohibit the merger and acquisition or prohibit the merger and acquisition and directs the parties to modify, change the arrangement to avoid that effect of having SLC, or totally prohibit the merger and acquisition unless and until the pertinent party or parties enter into a legally enforceable agreement specified by the Philippine Competition Commission. Okay, so a very 4 remaining slides. PCC's enforcement regime. You will note that the powers of functions of Philippine competition, it does function. It has quasi-legislative and quasi-judicial nature because it has the power to enact rules, guidelines, etc., etc. And of course, it is a quasi-judicial body, and as such, it does have a tripartite role as an investigator, prosecutor, and as an administrative judge. The PCC has also original and primary jurisdiction over all competition law matters. Okay, procedural characteristic. You have 3 adjudicative functions of the PCC. You have the power to determine anti-competitive agreements and conduct, power of preliminary inquiry, which is requirement for criminal prosecution and civil actions, power to review merger and acquisition. So again, the 3 stages of the enforcement: preliminary inquiry, full investigations, and then adjudications. In the case of filing for a case before the PCC, it's enough that you have a consumer standing. Now you can file. Cases decided by the PCC subject to review of the Court of Appeals under Rule 43. Okay, under the law, the Office for Competition still functions as the proper forum for criminal action. But take note that unlike the antitrust divisions of the United States, the Office for Competition cannot initiate a preliminary investigation until such time that the under the Philippine Competition Act, okay, until such time that what is it that the PCC had done its preliminary inquiry. But that is insofar as Section 14A and Section 14B. But as to other statutes like the Price Act, the criminal prosecution, and even under the Bayanihan Law, which is an antitrust statute, will not have to pass through the Philippine Competition Commission because they are not subject to preliminary inquiry. Again, I'd like to repeat, only Section 14A and Section 14B is subject to preliminary inquiry before a party can file a case to the Department of Justice. In other cases, the Office for Competition can initiate a preliminary investigations. And finally, for private enforcement, again, it is not the same with that of the private enforcement in the United States. Private enforcement under Section 45 is subject to preliminary inquiry. Therefore, you cannot file a suit directly to the court until such time that the PCC had done its preliminary inquiry. Okay, so who can file a private actions under Section 45? Only those persons directly injured by the anti-competitive conduct or anti-competitive agreements or the prohibited merger can file a private actions. So that ends my presentations. But if you are interested, ladies and gentlemen, oh my goodness, You can read. I have listed there as suggested readings. You can download them. The link is there. You may visit ssrn.com. I've uploaded there 2 articles that are relevant. The Philippine Competition Act, a mestiza, that explores the hybridizations of the law. And also I've discussed another article on institutional design of Philippine competition law that also speaks about the institutional design of our competition law. So I think that ends my discussion. I hope you've learned something. Anyway, this is just an introduction to Philippine competition. I know that eventually those taking the 2020 bar that is moved to 2021, in the review centers that you'll be attending, your professor will be, the reviewer will be talking about competition law. Also, in your commercial law review, I do understand that your commercial law review professor might have also covered this law, which is an emerging law, very unique, very interesting law. And I hope also eventually in the revised, eventually it will be included in the revised curriculum, model law curriculum. It will be included because it's now part of the bar examinations. So again, my dear friends, I hope, I'm sorry if hindi ko na kompleto yung aking presentations. Kung mayroon man akong pagkukulang, I hope I can answer your questions, but I don't have the time, I think. Yes, so maraming salamat. Thank you very much. I know that some posted some questions. I hope naintindihan nyo. I hope I wasn't too fast with my discussions. Thank you, Professor Attorney Leonard Mann, that you're listening. Okay, thank you, Philip, John. Thank you, Babit, Dayway, Truman, Dibaratan, Daniel, hello, John, Yuson. Yes, you're welcome, Amabel. Yes, you're welcome, Aramara. You're all welcome. Everyone are all welcome. Thank you very much. I hope you've learned something. If you have any questions, I hope we'll bump each other and I can answer your questions. I'll try to answer directly your questions to the comment sections. No, I hope I can answer all the questions. Once again, I would like to thank the president of the Philippine Associations of Law Schools, PALS, President Dean Mari, and Dean Alswade for this awesome project. I know that it would have been better if there's a slide because we prepared something. My virtual background was then amazing, but unfortunately there was a problem on the Facebook integration, so I couldn't do it via Zoom. And so I have to do it through Facebook Live. And so some of you might have a difficulty in following through the discussions because of, you're not seeing the slides. But again, you can download the slides and take note of the amendment, the corrections that I mentioned kasi may typographical error sa aking slides. So again, please, you can download those articles if you want more in-depth analysis of the law. I've uploaded the link to the slide. So I think I am done. Oh my God! Thank you so much, and good luck to everyone. You stay at home. I am praying for everyone's good health and safety. Mabuhay po ang Pilipinas. Mabuhay po ang Asosasyon ng Legal Education ng Pilipinas, the Philippine Association of Law Schools. Mabuhay po kayong lahat. Thank you very much indeed. Assalamualaikum warahmatullahi wabarakatuh.